Hello, and welcome to the League of Women Voters of Portland's Voter Forum for the candidates for election to Position 14 of the 4th District, Multnomah County Circuit Court. I'm Chris Kobe, member of the Portland League and the moderator for this forum. The League is a nonpartisan organization dedicated to making democracy work. We believe democracy works best when voters are informed about the issues and engaged in their communities. We are presenting this forum to give eligible voters the opportunity to learn more about these candidates. We are grateful for the support from the Carol and Velma Sailing Foundation, the Weiss Foundation, the Sarah Fruing Foundation, the members of the League of Women Voters of Portland, and our media partner, Metro East Community Media. The 4th District of the Circuit Court covers all of Multnomah County. All county voters are eligible to vote for candidates for this office. All 6 candidates for election to this office were invited to participate in this voter forum. 5 candidates were able to accept and are here today for this forum. In alphabetical order, they are referee Kristine Almquist, Bradford Gerke, referee Joseph Hagedorn, Michael Lee, and Elizabeth Savage. Welcome to all these candidates and thank you for participating. Under the voter forum standards for this event, each of the speakers will give a 1-minute opening statement, followed by questions we have prepared based upon league positions and league members' interest. Each speaker will have a 2-minute closing statement. Each speaker will have up to 60 seconds to answer each question. To determine the order in which the candidates will present their opening and closing statements and answer questions, we use the Oregon Secretary of State's current and previous official candidate random alphabets drawn in every election cycle. Mr. Gerke will give the first opening statement. Mr. Gerke?
Thank you. Hi there. My name is Brad Gerke. I'm an attorney here in Portland, and I've been practicing family law for 17 years. I'm running for this position of the 14th position in Multnomah County Judgeship. This is a family law position that's going to deal with divorces, custody cases, and dissolution of domestic partnerships. This is the field that I've been working on for 17 years, and I bring a lengthy experience in dealing with clients, with both mothers, fathers, children, and grandparents, that I think can help the community by having me and my experience on the bench. And I'm asking for your vote so I can bring that experience to the people. Thank you.
Thank you. Referee Almquist?
Yes, thank you. And thank you to the League of Women Voters for having us. I'm excited to be here this morning. I'm running for position 14 on the family law bench because I believe I can step into that position on day one. The reason I believe that is because I currently work as a full-time hearings referee and judge pro tem in Multnomah County. I sit at the Juvenile Justice Complex. I hear cases for families who are involved with child welfare. Those are our dependency cases, as well as juvenile delinquency matters. I also hear, because we're a one family, one judge county, custody matters and other matters, maybe protection orders that have to do with the families that we serve. So for me, we already considered part of the family law bench. And so I'm running because I believe it's a natural progression, and I'd be honored to be elected and serve on that bench.
Thank you. Referee Hagedorn.
All right, thank you. My name is Joe Hagedorn, and I am, like my colleague, Kristine Almquist. I have been a referee, a full-time referee and judge pro tem on the family law bench in Multnomah County. I'm running because I want to make a difference in the lives of women and children, or children and families. And every day for the last 6 years that I've been on the bench, I've learned how to work with the people that appear in front of me. So in my courtroom, this means meeting people where they're at. This means showing compassion and being curious and asking questions. And this means making sure that people are heard and not lectured. On both the juvenile and family law bench, I have been prepared to be ready to help and to motivate people to change their circumstances and solve their problems. And I think that is the thing that is the difference, is the experience in the courtroom and being on the bench for the last 6 years. Thank you.
Thank you. Mr. Lee.
Thanks, Chris, and thank you to the League of Women Voters for this opportunity. I am Michael Lee, and I am a prosecutor with the Multnomah County District Attorney's Office. I'm also serving as a major, a commissioned officer in the Oregon Army National Guard. I'm running for position 14 here in Multnomah County because I have a long history of public service, and I want to continue that streak of public service to continue serving the people of this county. For over 10 years, I've been advocating for victims, helping guide and advocate vulnerable crime victims through pretty unfamiliar and sometimes hostile legal process, which is criminal prosecution. And as an Army officer, I have a leadership training and experience and ability to lead from the bench that I would translate to a position on the bench. I believe the people deserve a vibrant and diverse judiciary, and I think that's me. I'm qualified, I'm ready, I'm willing, and I'd hope that the voters also see that.
Thank you. Ms. Savage.
Hello, my name is Elizabeth Savage, and I was born and raised in Multnomah County. I am a returned Peace Corps volunteer, and I was a high school English teacher for 8 years, working in struggling communities in crisis. I went to law school at Lewis and Clark. I've been practicing family law for the last 12 years, and I'm a pro tem judge where I hear Abuse Prevention Act hearings and stalking protective order cases. I think our community is in crisis right now, and I want to be part of the very important work of rebuilding the public's trust in our judiciary. Thank you.
Thank you. Those conclude the candidates' opening statements. Our first question goes to Ms. Savage. Position 14 has been designated as a courtroom to handle the family law docket as opposed to general civil and criminal cases. Describe what the most significant considerations would be for you as a judge in custody cases.
The most significant consideration in those types of cases is always going to be the child and their best interests. I've been a pro bono child's attorney for the last decade, and I'm a mom. And again, I was a teacher for about 8 years. Children are very important to me. I think one of the most important things to keep in mind in cases like this is that the parties lose sight of what's important. Sometimes they're entrenched in their conflict. Ultimately, it's the judge's job to guide them past that conflict and towards resolution, because the most important thing is the best interest of the child, and conflict can do nothing but harm the child.
Thank you. Mr. Gerke.
Thank you. Well, the legislature has already told the judges what they should focus in on, and that is the best interest of the child. And there's a list of factors, but I think really as a judge, to figure out what's in the best interest of the child, you have to really be able to parse the wheat from the shaft in a sense, and find out what's really important to the child, what really is important to those parents, and what small changes can make to, because they can make large changes to the child, how to minimize disruption to the child. And I think that's where you really want to look, is how to minimize the disruption. Ms. Savage was absolutely correct that a lot of times people come into the courtroom already entrenched into their positions and not ready to see anything beyond, I want to win. And unfortunately, there's no winning in a custody case. It is making sure that these parents are in a position that they can be in their child's lives beyond the age of 18 when the judges ruled in, and make sure that they're there for the children's wedding and there's not this extended conflict. And that's how I would focus my attention, is how to minimize that conflict in the future.
Thank you. Referee Hagedorn.
All right, thank you. And I would agree that the legislature has laid out the best interest factors, but I think the most important thing to focus in on custody cases is you really have to get to know the family. you have to work with the family and sometimes for years to really understand what the core of the conflict is. And I think judges really play that role once you get to know the families, is really to reduce that conflict. And that is the goal of, as far as the best interest in looking at the child, right? So I would say that I'm in that position to be able to do that. I've represented children for since 2006 in juvenile court, which is very unique to juvenile court to be able to do that. And I now, as a judge, I get to see and hear children every day in the courtroom.
Thank you. Mr. Lee.
Thank you, Chris. Really hard to follow up all those great answers, but I agree that the legislature does say that the primary consideration is the best interest and welfare of the child is the specific language there. The factors are listed out, but like the other candidates, my consideration would be, what does that mean in its holistic meaning for the child and the best interest and welfare? As a judge, as referee Hagedorn said, you get to know the candidates, or not the candidates, the litigants, the parents. You figure out what their situations are in life, and then you have to make a determination as a judge decisively about what custody situation or decision will best interest the child in terms of both financial, emotional, considerations that each parent can contribute to this child in order to minimize the disruption to the child's development and their growing up and their ability to maintain a good relationship with both parent moving forward. So truly, it's what's in the best interest of the child. Thanks.
Referee Almquist.
Yes, thank you. Well, so when thinking about the decisions that a family law judge makes on the bench, there's lots of custody decisions actually that we make every single day. In child dependency, welfare cases, dependency cases, we actually decide custody to one parent, to another parent. Maybe we give custody to an agency. Those are really, really difficult decisions that are also grounded in best interest and what's best for the child and for the family. When we're looking strictly at the family law realm, as stated by all the other candidates, of course, it's best interest with those factors, which is different than dependency. Those are very kind of different, the way you look at those different factors. But as a judicial officer, we have to decide custody issues all of the time. And I strongly believe in letting litigants present their cases to the judge. It's always facts, evidence, argument as applied to the law, and then hopefully to get to making that best decision for the family. And so I think when you're talking about the domestic relations, family law matters, custody, parenting time, the best thing you can do is listen to the litigants, receive the most information that you can in order to make the best decision for that family. Those types of decisions go to the heart of families. And so those are the type of decisions that can change the dynamics of a family for years to come. So those are some of the most important decisions. And as a judicial officer now and going forward, I always listen to what the litigants have to say and just try to make that best decision and give them that finality, which is what they're seeking.
Thank you. The next question goes to Mr. Gerke, and it is, what would be the most significant considerations for you as a judge in dealing with self-represented litigants?
I think it's making sure that they have a full understanding of what they're trying to present to the court. Oftentimes people come in without a good sense of what is important, what they're looking for. And I think it's important for a judge to lay out the process at the very beginning, lay out what the expectations are, and lay out what they're going to be looking for so that people know what to present and know how to help the court. 80% of the litigants in family law in Multnomah County are unrepresented. And that means they go in trusting the court to help them make a decision. And I think it's important as a role as a judge to help these parties understand the process so they're not blindsided and so they can understand what's happening to them. Thank you.
Thank you. Referee Almquist.
Yes, in family law cases, as just stated, it's true that many folks come in self-representing themselves in a system that may not make a lot of sense. And so I think it's our job as the judge, as a judicial officer, to help folks understand the process, help them understand just the logistics of getting the information to the judge that they seek to provide. Kind of goes back to my answer with the last question, which is, to the heart of it is making sure that folks, no matter who they are able to present their case to a judge, get the best information and the information that they want in front of the judge so they can feel heard. Whether they have a lawyer, an attorney, or they're self-represented, everyone needs to be able to present their best evidence. And so as a judge, it's our job with self-represented litigants to make sure that they have the access to the process. If they have questions, you answer, that you take more time if needed, not to do their case for them, but to give them the avenues and the paths to present the information that they would like to present. And just treating them with respect and always remembering that the decisions that we're making, as I said, go to the heart of their family, and we want the best information and the most information. Thank you.
Thank you. Mr. Lee.
Hi, thanks. So like Brad said, most of the litigants that come into family court in Multnomah County are self-represented. Now, as a deputy DA, as a prosecutor, I have experience that's directly relevant. Contrary to common belief, prosecutors do not represent victims. However, we are closely tied with victims, and we have to be educators for victims. Just like a judge cannot represent or litigate on the behalf of anybody that comes before them, but they are educators. They manage expectations. And these are the things that I think would be my significant considerations for self-represented litigants. Judges have to educate, they have to manage those expectations, but also, and more importantly, on the back end, after those decisions are made, they have to have the patience to explain in common language, not legalese, so that regular lay people can understand why a judge makes a decision that they make. What is the reasoning? And make sure that even though these results can be difficult, they are understood. Thanks.
Thank you. Ms. Savage.
Thank you. Over the last couple of years, I've been a pro tem judge, and almost every single case I hear involves pro se litigants. That's unrepresented parties. They come in there sometimes. They've never been in a courtroom before. It's their worst day. It's really important to dispel that fear by being clear about what the rules are and how decisions are going to be made. I do see some overlap with my career as a teacher, living and working amongst people from all walks of life. I think one of the most important things you can do is lay out expectations clearly, talk about how the facts are going to be applied for the law, and then before giving the decision, again, go through the statute and discuss how the evidence led to that result. Even when folks aren't happy with the outcome, it's important that they understand how it was achieved so that they don't feel like justice was done to them, but they understand that they were heard. That makes them walk out of that courtroom with more faith in the system than when they came in.
Thank you. Referee Hagedorn.
Thank you. So I will agree. On the website, I think it says 70% of the people in family law are self-represented litigants, but I think it's closer to 80%, as Mr. Gerke indicated. As I've mentioned before, I think families really that come before, that are self-represented, often bring a lot of things with them into the courtroom. And I'm very specifically talking about trauma, right? So that's something that we see a lot in juvenile court. It's something that also we see on the bench in family law court, right? So you have to really have some training on how to do that, on how to work with those folks. And that means it's important that judges understand first the signs of trauma and stress in a courtroom. And then the judges also have to do some things themselves, really, to make sure that that's not happening. That includes keeping your emotions stable, limiting any interruptions in the courtroom, promoting fairness, being patient. And it also includes making sure that people understand the process, as others have stated, and that is making sure that you educate people ahead of time. Sometimes that might include providing a letter.
Okay.
Go ahead.
No, I was just going to say you need to wrap up your answer. Go ahead and finish your sentence.
All right. Thank you. Thank you.
Very good. Okay, the next question will go to Referee Almquist. What, if any, weight should voters give the number of a judicial candidate's financial supporters, the identity of their donors, and the amount of their average contributions?
Well, I believe in the democratic process, and this election is quite exciting because not just for this position 14, but for all of the positions in Multnomah County, there's a lot of folks interested in running. It's the financial part of a judicial election is very interesting. As folks all here know, as candidates, we're not allowed to ask for or solicit money contributions. That's not something that we're able to go out and do, despite the fact of the matter is that to be a candidate, it takes resources. I think that transparency is always better. I think that having that information out to the voters so they can see who's donating to which candidate and how much, it may inform them or it may not. My whole piece in this is just that it's transparent. I think we have that system in place. Maybe there's improvements that could even be made on that transparency piece to see if it should be given any weight at all, but I leave that to the voters.
Thank you. Mr. Lee.
Yes, thank you. So I agree with Referee Almquist that transparency is key. I do think that voters will infer whatever they wish, as they should, in terms of what they think it means when they look through a candidate's campaign finance accounts and look at their donations to see if there are, political parties that donate or corporations or businesses or what have you, rather than individual donors. So I think that the beauty of our democratic system is that each voter must make their own inferences. They have to vote with their conscience and whatever their personal beliefs are and what those donations mean and what that money means for each candidate. But as Referee Almquist said, I completely agree. This takes money. It does take money to run for the promotional material, for the yard signs and the literature. That all takes some money and the support of the community to each candidate for it to be a viable campaign. Thank you.
Thank you. Mr. Gerke.
I have a different take, I think, on this than many. Generally, in elections, it's very important for us to know who is propping up a candidate. This position is interesting in that it is a family law judgeship position. There's not the special interest that one would expect to see for this kind of position. And so a large sum coming in to parties would be very unexpected and unusual in this kind of case. I have not taken any donations at this point in time. I've not set that up. I'm not doing the advertising that some of the others are because I'm relying upon my experience. But I don't know that this would be the issue that any candidate or any voter should put their weight on. I think this is an issue of minimal weight in this specific election. I think that just may not be a popular answer, but that is the truth of this election in this specific spot. I don't think any of the candidates here, I think I heard the other day that $30,000 was the most that some had, and the majority were under $10,000 in terms of their donations. So I don't think that's a significant play in this specific election.
Thank you. Referee Hagedorn.
All right, thank you. I'm in agreement with the others. I like the aspect of the transparency in it, to know who the donors are. I think that's been interesting for me to do that. I am not a politician, as others here are not either. And so trying to raise money without really raising money has been really difficult because you can't talk to people directly about that. However, there are some other great things that you can do, and that includes making connections with people, in the community. So it's given me an opportunity to do that, otherwise. But I'm in agreement with the transparency aspect of this, and I wish it weren't the thing that I needed to do to become a judge, but it is what it is.
Thank you. Ms. Savage.
I think all of the candidates have discovered that politics is a messy business when it comes to raising money. And I know that local campaign finance limits, which don't apply to judges, actually limit contributions per single contribution. They're capped at 600. That's a provision that is scheduled to apply to judicial candidates going forward. However, it keeps getting pushed back. So without taking a political position, which of course I can't do, I can say personally, I think it would be a lot easier on all the candidates were there not that pressure to raise money, because ultimately this shouldn't be decided by money. It should be decided by who the best person is for the job.
Thank you. You are watching the video of the voter forum of the League of Women Voters of Portland, or listening to our podcast for the candidates for position 14 for the 4th District Circuit Court, which is Multnomah County. The next question goes first to Referee Hagedorn. What would be the most significant considerations for you as a judge in deciding issues of alimony and support?
Right. So the most significant, I think, considerations is really to understand the compensatory, the transitory, or transitional, as well as, let me just check and make sure that I have all of them, and maintenance, right, in the support. Those are the things. It's really just to understand understand the families, understand where they're at, what's needed for the spouse that's making that is making the less money in the case. And so I think those are really just to consider those three things in the alimony and support maintenance.
Thank you. Referee Almquist.
Thank you. Well, from my perspective, it's always best when families, if possible, can come to some of those agreements on their own, even if they still need to use the court process and use a judicial officer to make some of those other decisions. So if families come to a stipulation, that's always best. However, if a judge does need to step in and rule on child support, that's statutory. Those factors are built into the law for us to rule on. And then with regard to alimony, that is not statutory, but there are factors that a judge should consider when looking at that. Again, as always, I look to the litigants to present their information, their best information to the court. And then I would be able to apply that to the law and the factors to hopefully make the best decision for the family.
Thank you. Ms. Savage.
Support, both spousal support and child support, are issues that I've dealt with extensively on appeal. I have a robust appellate practice, and that's been really interesting to dig into the underlying administrative rules and guidelines that underlie these policy decisions. With respect to the child support guidelines, there is a guidelines calculator that anyone can use, and that really does dictate the presumptive amount of support. And then there are factors that can justify an upward or downward departure. With respect to spousal support, it's really about the contributions that the parties have made. It is more of a just and proper analysis with room for discretion by the court. Maintenance support is almost always the most appropriate form of spousal support that's given. And that will usually have to do with the lifestyle of the parties and the relative ability of each parties to earn income and to support a similar lifestyle. Not all contributions are financial.
Okay. Very good. Thank you for your answer, Mr. Lee.
Hi, thanks, Chris. Could you repeat the question just to make sure that I'm staying on point?
Sure. What would be the most significant considerations for you as a judge in deciding issues of alimony and support?
Okay, thank you. So, as the other candidates have talked about spousal support, referee Hagedorn kind of mentioned the three major categories of that. But for me, regardless of the kind of support, the guiding watchword here is equity. It's fairness, right? So if you look at traditional heteronormative gender roles, if you will, in a marriage, like Ms. Savage was saying there at the end, not all contributions are financial. And I think the policy, starting with the factors that were laid out by the legislature, kind of reflects that, right? Because it's not just about who brought the most money in. It's about who took care of the family, took care of things at home, the amount that they've contributed emotionally as well, and all that. So the important thing is that these factors, even in the legislature, under each type of support says any other factor the court deems just and equitable. And that word equitable goes to the primary consideration of any sort of support decision. What is fair? Thank you.
Thank you, Mr. Gerke.
Thank you. This is an area that I've been dealing with in my 17 years extensively. In fact, spousal support, alimony, that along with child custody are the two most contentious parts of a case. Ms. Savage is right. The judges are going to be looking to what's just and proper. And that's really looking at what they've done, what their plans were as a partnership. And really, the judge should be looking to create a path to self-sufficiency for both parties. And that's really what that's going to do. Certainly, we want to look at all the just and proper and the length of the marriage and the statutory factors. But I really think a path to self-sufficiency is an important thing because these parties have spent their portions of their lives together, working together, and now when that partnership dissolves, you can't have one person be significantly better off than the other. And I think bringing up parties to the point where they can live without the support of each other in the future is what we want to do. And that may be done through the transitional support, which is an underutilized section of support, I think. Thank you.
Thank you. The next question goes first to referee Almquist. What if any objective, public, quantitative information is available to voters to assess the performance of a circuit court judge? If you are not aware of any such information, should such information be available to the voters, and what would it be?
Well, thank you for this question. So I think what I've learned through this process is despite forums such as this one, that there seems to be room for improvement in providing information to the voters. Like I said, I believe in the democratic process. It would seem that the voters should absolutely have a voice in the folks that they're choosing to make these decisions about their families. But the question is, do they have the avenues for all of that information? And I would say I think there's room for improvement. I've also been thinking about transparency in our courts a lot throughout this as I've been running in my campaign. And what does that look like for judges to receive feedback once they are on the bench in order to improve the processes? I feel like that is an area that's significantly lacking. So that goes beyond just this campaign and just the process. But what would it look like for there to be an avenue for judicial officers to receive feedback and improve our courts? I think there's room for improvement in the election process and then when we're there on the bench as well. Thank you.
Thank you. Ms. Savage?
Well, I think one of the most clear areas of feedback for a sitting judge is if they are appealed and reversed frequently, That's something I deal with quite a bit. I will say that there are certain judges who I won't name, both in Multnomah County and otherwise, who have a higher rate of appeal because they perhaps don't take as much care with applying the law correctly. I think it should be every judge's goal to get it right. And if that means recognizing that you don't know the answer, requesting supplemental briefing, or even taking a little time to figure out what the law is and how to apply it. We run into novel questions of law all the time, and it's really important that judges strive to get it right.
Thank you. Mr. Lee.
Yeah, thanks for this question, Chris. What an interesting one. And I will say that in my career of being basically in the courthouse and in courtrooms as a prosecutor almost every day of my legal career, I can say that I'm not aware of any publicly available information or metrics that are tracked for judicial performance that will allow voters to then evaluate the efficacy and efficiency of their current sitting judges. I think it's an interesting idea. Judges deserve feedback just as much as any other legal professional. And I recently have become more confident in my position and my experience to be able to start giving feedback. I will say earlier in my career, that's a very daunting and sort of scary thing to do when you have to appear in front of that judge again in the future. But my experience recently has been judges are people too, and they want that feedback. And voters deserve to know these things as well about the judges that they elect. Judges are public officials. They're beholden to the public. They're paid through the taxes of people of Multnomah County and the rest of the state. And so as those public servants, I do think that they should have that information publicly available for the voters to review. Thanks.
Thank you. Commissioner Hagedorn?
Referee Hagedorn.
Sorry.
But it's okay. So one of the things that I want to note for people is the courtrooms in Oregon are open to the public, right? So that's an important process. And that's also an important process really out here in juvenile court. People have that opportunity to see what's happening, to see the lives, how the court works with folks. So that gives a lot of input for judges. And I agree also, and then that's a struggle, is lawyers don't want to give the input to judges. But I think they can. I think there's no rule that restricts that to be able to provide that. And lawyers, they certainly have opinions, and they spread those opinions in the community of what they think of the judges that they appear in front of. But I think you can give it directly to people. I think it's an interesting question that you've asked, but I think that is a couple ways that the community can go out and find out what's happening in our courtrooms.
Thank you. Mr. Gerke.
Thank you. Very interesting question. I was intrigued by the other answers. The mechanisms are there for the public. I just don't think the public or any even special interest groups would want to do the work. We have a system called OECI where parties can go in, look at what the court documents have been, what the rulings have been, what the findings have been. You can see judgments on cases. For example, if people wanted to find out what Judge Joe Blow did over, for spousal support for the last year, they could go look at every case that he handled and look at the findings of facts and what the spousal support was. Information's there. It's just so voluminous, it's hard to track. Ms. Savage mentioned the appeals process, and even when there are appeals and overturned and just blatantly wrong decisions by judges, nobody outside of family law knows. So unfortunately, it's a situation where it falls on deaf ears, and I wish it didn't. So I encourage the voters to look into these kind of things, to listen to attorneys when they say things about, when Judge Hagedorn mentioned, go listen to other people, judges or attorneys talk about others' opinions. Go find out what the opinions are. Because I think that's important to have that moderation. Sorry.
All right. Thank you. The next question will go to Referee Hagedorn, and it's a little bit simpler than the previous questions. It is, what would you expect to be the most satisfying and the most challenging aspects of serving as a judge handling family law matters?
Okay. Um, so I think the most challenging aspect is the conflict that you experience. And as I've mentioned previously, to really understand the information that's coming in, you also have to be vulnerable and accepting of that information. And that can take a large toll on you to be carrying that with you. I continue to find ways for myself to figure out how to move through that. I exercise a lot. I spend a lot of time with my family, which helps me to give perspective. And so I think that's the most challenging aspect throughout the family law bench is the conflict and the suffering that people are experiencing in the court, right? Is it also that trauma aspect?
Thank you. Ms. Savage.
I think the most satisfying part of the job here would be getting it right. We've many of us been advocates, and that is a really fun job. But helping families to move beyond conflict, to become successful co-parents, to have some finality in their lives, that is really, really satisfying. As far as the challenge, I think it's been scientifically shown that every one of us has unconscious bias and brings our own experiences and personal feelings. To recognize that in every case, to check one's own preconceived notions at the door, that requires constant vigilance and keeping an open mind, hearing everybody's point of view. The worst thing I think a judge can do is come into a case before hearing it with some preconceived idea about how it should go. And I think it's important to always be vigilant and watch for those preconceived ideas at the outset of a case.
Thank you. Referee Almquist.
Thank you. Yes, well, there's lots of satisfying aspects to being a judicial officer, and I see that every day in my courtroom, whether it's seeing a child go home and be reunited with a parent, or just seeing someone with their own small successes. Maybe they're in treatment, maybe they're making those strides for themselves, and you can celebrate all those positives along the way with the families that we serve. We do adoption ceremonies, and even guardianships you can celebrate. So there's all sorts of satisfying pieces to the job. That applies, I think, in the family law area as well when we're talking about custody and parenting time and giving that finality to families. There's a lot of challenges as well, as been mentioned here, which is that's also really difficult work. Folks in crisis, folks in trauma, and we're the ones that have to make those difficult decisions. That's the job, but it can also be really difficult on the judge making those decisions. So you just have to take care of yourself, and I think that's the most that can be done in this job.
Thank you. Mr. Gerke.
Thank you. I think the satisfaction of this job would largely come from the mental challenges that come from this job and being able to help people by thinking creatively. I'm just in court yesterday with Judge Henry, and at the end of the long day, he brought a very creative solution to stop the last bit of drama that was affecting these parties. And I think being able to help people solve their problems by thinking creatively would be a very satisfying thing to do. In terms of the challenges, I think the challenges are always going to be how people feel and react to you, because you are the person that's going to tell them you can't see your child as much as you want. You have to give this other person some of your money. You are bringing bad news, and people come in with a very self-centric view, and they're going to be upset that somebody is telling them they can't have what they want, and including something that's so dear to them as their children. And I think that would be a very hard part to deal with.
Thank you. Mr. Lee.
Yeah, so I'm going to reference something that Mr. Gerke said actually in a previous other interview, but in terms of the satisfying thing, I think it'd be difficult to get that positive feedback as a family law judge. If you get it right, hopefully the parties or the litigants never come back. And the folks that keep coming back are the ones where maybe you did something wrong or maybe we're not creative enough. If I were elected, though, the one thing that I am most looking forward to would be an adoption ceremony. There isn't a single unhappy person in the courtroom when those things happen. I think it's important to celebrate the wins that are right in front of you to keep you going in a job as taxing as a judge. Now, flipping the coin to the most challenging thing for me, it's just the level of emotional connection that is tied to these cases. For good reason, we're talking about family relationships and the high level of emotion that that's going to come with, the conflict, like referee Hagedorn has referenced, and then the challenge of understanding people and their motivations and how that might be coloring the case that they're presenting. So I think I would find that most challenging. Thanks.
Thank you. Those are all the time we have for the questions. So now we'll move to closing statements, starting with Mr. Gerke.
Sorry, I forgot to unmute myself. Thank you. As I said earlier, I've been doing this for 17 years. I've been doing only family law. Every day I am talking with and working with clients. I understand the emotions that are in play, the positions that are in play, the needs that are in play. This is what I do and what I've made my career out of doing for the last 17 years. I think I'm very qualified to bring that experience to the public into the bench. Like I say, I've represented husbands, wives, grandparents, and children. I have a experience helping each and every type of client that can come through the door or come into the courtroom. And I understand their needs, their emotions, their positions, what's going on in the background. I have the creativity to allow me to help them when they are so blinded by the animosity that's led them to the courtroom. One of the things that people don't understand a lot of times is for the people to get to the courtroom, they've gone through mediations and months of opportunity to resolve this case without a judge. And they are at their wits' end and saying, I cannot resolve this without help. And I understand that. I will be seeing people on the bench on their worst day. They say sometimes a family law judge sees people on the worst day of criminal law, sees them on their best. They're going to be on their worst behavior because these are issues that are near and dear to their heart. We are dealing with children on a day-to-day basis, and one can understand how that can tear up a family to have fights about who should be able to see their children and limiting a parent's ability to see their children or talk to their children. These are very important issues that need thoughtful, experienced, reasoned results, and I can bring that, and I appreciate the opportunity.
Thank you. Referee Almquist.
Well, thank you. Yes. Well, my case as a candidate is, I've been working in the legal system since 2003 as a legal assistant, a paralegal, and then beginning in 2008 as a law student, law clerk, working in the juvenile division of Multnomah Defenders, working for attorneys, then to becoming an attorney myself for 11 years before taking the bench in 2021. And now I've been a judicial officer, full-time hearings referee since 2021. So I've worked through every area of the law office, of the courts. I know the nuts and bolts of the job behind the scenes. And then I know what it's like to be on the bench and run a courtroom and to be a true neutral, which is what the job is. So I think it just comes down to experience, which I have. I love my job as a hearings referee and judge pro tem. So it's not in theory, it's in practice that I love this work. I love the folks that come in front of me, giving me the opportunity to serve the public, because that's really what it's all about, is being able to have the opportunity to serve the families that come before the court, and always working hard to receive that information and give them the best decision that we can make. and giving them the finality to these important issues. So being a judicial officer is a lot of different things, but I think just being able to properly not just receive the information and then make the decisions, and then do that quickly, and do it in a way where folks can understand. And as always, having a fair and impartial courtroom where hopefully folks feel like they have the ability to have their matters heard. And I would be honored if I could be elected to position 14.
Thank you. Referee Hagedorn?
Thank you. So as I've noted previously, I started my career in 2003. I worked as an AmeriCorps attorney down in Albany, Oregon, representing survivors of domestic violence, and then worked as a public defender for 17 years, doing everything in the public defender's office, trying hundreds of cases, including misdemeanors and serious felony cases, including murder trials. But I've also worked in the treatment courts, mental health court, drug treatment courts, and those skills have really helped me to see and work with the people that I'm working with now on the bench. It's given me a broad perspective of how things need to happen in the courtroom, how you need to motivate people to make changes in their lives, especially in juvenile court. But I think that's also in the family law bench, that you need to motivate people to remove that conflict in the court and finding ways, keep thinking about ways that you can do that never ends. You never stop learning to do that in your journey as a judicial officer. And again, I've been on the bench for 6 years, and it has changed in trying to figure out what barriers need to be overcome. I love this job. I am excited to the possibility of doing everything in family law, and I look forward to continuing my efforts to make lives better for children and families.
Thank you. Mr. Lee?
Thanks, Chris. So in closing, I just want to say that this has been an amazing experience running as a candidate to try to gain the opportunity to serve the people of Multnomah County. And I will say, as I said in my opening, part of the reason why I'm running is because I believe the people deserve a judge and a judiciary that is diverse and vibrant and includes people that are from a varied backgrounds of both cultural histories, lived experiences, and professional backgrounds. Every candidate here is smart. The law can be learned. And I will be frank with your voters. I do not have the family law experience that Mr. Gerke and Ms. Savage have. They're very seasoned practitioners. But what I do have is that I am the best all-around candidate for this job. What you can learn legally, any of the candidates here could do that. It's who you are in your temperament and your abilities in leadership and decision-making and communication and your ability to educate, empathize, show compassion. Those are all things that I have developed. I've been forged through my life experiences to be able to do that effectively on the bench. I'm the only candidate that can say all the following things apply to them. You know, I'm a born and raised Oregonian. I'm a male. I'm the son of Korean immigrants. I'm a prosecutor and have tons of trial and hearing experience. I am a veteran, having served twice in the Middle East, the latest deployment being under combat conditions, being charged with making life and death decisions. And that's without hyperbole, life and death. So it's my belief that I'm the best candidate for this position, that the legal knowledge can be gained rapidly, and that I can be the most, or that I would be the most effective judicial officer if elected by the people to serve them. Thank you.
Thank you. Ms. Savage?
Well, first, thank you to the League of Women Voters. It's been an honor and a privilege to serve as part of this panel amongst such other qualified candidates. I think what does make me uniquely qualified for this seat is that I have both family law experience and judicial experience. I am a former teacher. I've done things other than practicing law, and I think it's important to know what it's like to live and work alongside folks in impoverished communities. That's an experience that I have and I take seriously. Ultimately, it's going to be up to the voters who they choose. I will say that I am passionate about serving our community. I was born and raised here, and I would like to be your judge for position 14. Thank you.
Thank you. That concludes the closing statements from the candidates. For position 14 for the 4th District Circuit Court, Multnomah County, and we thank the candidates for their participation. Audience members, please share this forum recording and podcast with your family and friends. We all need to be informed voters, especially about judicial candidates. If you are registered to vote by April 28, you should receive your ballot by May 6. As with all Oregon elections, almost all voters will participate in mailing in their ballots, although in-person voting is also available. Check either the Multnomah County voters pamphlet online or the paper copy when it arrives at your household. Ballots will be mailed starting April 29. To be counted, ballots must be postmarked by Tuesday, May 19, Election Day, at 8 p.m. The League of Women Voters strongly advises that if you are going to return your ballot by mail, that you mail it at least 1 week before Election Day. That is by Tuesday, May 12. You can also find an official ballot drop box location near you by checking vote411.org or in the Multnomah County Voters Pamphlet. If you drop your ballot in an official ballot drop box, you have until 8 p.m. on Election Day to do so. The League of Women Voters is a nonprofit, nonpartisan membership organization. We hope this forum was meaningful for you. We welcome you to join the League or to contribute to the cost of these services at lwvpdx.org. This is Chris Kobe for the League of Women Voters of Portland. Thank you for watching and listening and for being an informed voter. And remember, your vote counts.